Hello everyone and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. In today's episode, we're looking at Sun International Management versus Saiti, a recent Labour Appeal Court decision dealing with religious accommodation in the workplace. Now, the case involved a marketing manager who, due to his Seventh-day Adventist faith, couldn't work on Saturdays. His employer had initially accommodated this, but after 16 months, said the arrangement was no longer sustainable and dismissed him for incapacity. Now, the Labour Court found that the dismissal was automatically unfair, but on appeal, the Labour Appeal Court took a different view. It ruled that weekend work was an inherent requirement of the job and that the employer had gone as far as it reasonably possibly could to accommodate him. The dismissal was upheld as fair, and the case raises critical questions about the limits of religious accommodation at work and what employers are expected to do when beliefs and business operations collide. I can't quite believe we're already at episode 10. Double digits, Debbie. It feels like such a milestone. But before we dive in, how are you doing, Debbie?
Thanks, Aisha. I'm doing well, thank you. Episode 10 is indeed a milestone for us. That's fabulous. And how are you holding up with Ramadan?
I'm actually good. Thanks so much for asking. I must say, though, it is quite an exciting time because we are almost at the end of Ramadan. So Eid is right around the corner. And I think in some ways that ties in very well with our discussion today. I actually didn't know if you knew this, but we have Easter, Eid, and Passover all coming up or overlapping in some way. So I think it's a period where many people are observing their faith, and I think it makes today's discussion about the Sun case very fitting. So let's just dive right into it. Today's topic raises important questions about how far employers need to go in accommodating religious practices and where the boundaries actually are. So Debbie, what are your initial thoughts on the Sun case? Do you agree with what the judgment was?
Quite apart from the decision itself, my initial thoughts really go to the indicators for labour justice, because these include efficiency and speediness. That a dispute, particularly a dispute involving dismissal, can be resolved in a manner that's fairly efficient and speedy. And in this case, we have a dismissal from 2016, which was heard in the Labour Court in 2022, August 2022, which would have been around the time most likely of COVID lockdown, towards the end of lockdown. So we've had an intervening pandemic, which would also have impacted on the nature of the role itself. Yeah, and the decision itself, I do have some concerns about what this means for the boundaries in terms of how far employers need to go, but that will probably come up later in the discussion. What are your initial thoughts, Aisha?
I agree with you. I think we are going to get deeper into it in the conversation of the podcast, but I think it raises a lot of critical questions just about the limits. On the one hand, you have an employer who made efforts to accommodate the employee's religious practice for a significant period, and then it sort of reached this operational limit. But on the other hand, you have this outcome which suggests that an employee's religious observance may not be as important to operational needs if that accommodation becomes unsustainable for the business itself. So I think that if you look at the employer's position, it's understandable from a business perspective, but it is concerning that, there could have been other ways to fully interrogate this. And I understand the ruling, but I think, it raises a lot of uncomfortable questions about, are we fully protecting religious freedoms in the workplace? And I think we'll get into that as we jump into the next question. And I think this is where I'm going to ask you, what are the Sun judgment's key implications for employees and employers? Do you think it shifts the boundaries on how far employers must go to accommodate religious practices? And does it strike a fair balance?
I think employers are likely to be happy with the outcome in the Labour Appeal Court decision. It determines the responsibility of accommodation and the point of undue hardship at a relatively low burden. In this case, it was the burden that was placed on the fellow employee who had been carrying Mr. Sayeti's responsibilities during the Sabbath hours. And, it does raise questions around whether this is shifting or bringing the boundary back, shortening the responsibility on employers. The decision does provide clarity for employers, and the fact that an employee cannot rely on contract terms if the position is advertised in a particular way or the contract itself is silent on weekend work in circumstances where it is clear that weekend work is essential for performing the job. So in both judgments in the Labour Appeal Court, there's an acceptance that weekend work is essential for the job and that the employee should have been aware that he would be required to work on Saturdays. So employees will no doubt be happy with the decision. From an employee's perspective, I think the judgment's a little bit more concerning. Of course, as a general rule, employees are not required to disclose personal information at the time of recruitment, and that would include religious beliefs. But it appears from the judgment, and of course, if he had been more forthcoming about his religious beliefs or his ability to work on a Saturday, he would not have been hired on the basis of inherent requirements of the job, which has implications for religion, particularly those for whom the Sabbath is on a Saturday. So it raises questions from both the employer and employee perspective about what is required by both parties, both during the stage of recruitment in terms of engagement at that stage and clarifying the roles and responsibilities of the job and its inherent requirements, but also questions around the policies and practices to ensure reasonable accommodation is embedded in the employer's policies and practices, and accommodation on grounds of religion, but other grounds as well, and ensuring that workers can achieve some form of work-life balance that recognizes their characteristics and needs outside of the workplace. We also don't see much coming out of the judgment in terms of innovative ways to fulfill essential requirements without an undue burden on employees based on their religious beliefs. We see how an employee is accommodated to attend Friday prayers by leaving his business card and other means, and it's not really explored if there was an equivalent type of accommodation for the employee. So I think the implications are a little bit troubling.
So one thing that I actually think was interesting about this judgment was that the case was actually read alongside the very recent case of TFD Network versus Ferris. And I think, like we said, both cases dealt with the Seventh-day Adventist employees working on Saturdays. It also shows that courts are willing to accept employers' claims of operational necessity over employees' religious objections. What kind of precedent do you think this case sets, especially when read alongside the Ferris case?
So both the Labour Court and the Labour Appeal Court, and the Labour Appeal Court in both its judgments sets out the key principles in the Ferris case. So the principles really remain. There's a confirmation around the principles as were set out in the Ferris case, which is really those two steps, those two stages. And the first is the test for an inherent requirement of the job. So it's whether a requirement is inherent or inescapable in the performance of the job, and indicating that this is a proportionality inquiry, that the requirement needs to be rationally connected to the performance of the job. The difference, of course, between the two cases is that in the Sun International case, it was found that working on a Saturday was rationally connected to the performance of the job, whereas this wasn't so much the case in TFD. The first leg, or the first hurdle, is this inherent requirement of the job. And then the second step is, even if it is an inherent requirement of the job, employers need to go one step further, and the employer bears the burden of proving that it is impossible. So this is the wording in the Ferris case. The employer bears the burden of proving that it is impossible to accommodate the individual employee without imposing undue hardship or insurmountable operational difficulty. So really, the question we need to ask ourselves in Sun International is whether it was impossible to accommodate Mr. Sayeti without imposing undue hardship or insurmountable operational difficulty. The evidence of undue hardship in the Sun International case is really the hardship, placed, or the burden placed on the individual who had in fact employed him, Ms. Beatty, who was doing her responsibility as well as his. The cases differ on the facts, but I do think we need to ask questions around whether reasonable accommodation, and not just from the employer's perspective, but also from the employee's perspective, whether reasonable accommodation was adequately explored and ventilated in this case. And we don't know from the facts, and of course we always acknowledge the limitations, and we're bound by the judgments and what's included and stated in the judgment. This is a big employer, and of course Sun International, it does operate internationally and 24/7, so it will have implications based on religion. So it would be interesting to see whether those principles are sufficiently robust for the multiple different cultures that the organization operates in. It also would, the operational requirements and the cost factor, for me, it raises questions around similar to those in the Standard Bank versus CCMA case. That was slightly different because it dealt with accommodation in the context of an injury on duty where the burden is greater. But if we accept that, placing an undue burden on a fellow employee is adequately meeting the threshold, it's likely to mean that there are multiple occupations and professions which would exclude people from particular religions implicated by the judgment.
I'm so glad that you spoke about, reasonable accommodation. And I mean, like I said, we have to get into this discussion now of religious accommodation and what lessons do these cases teach us about how to handle religious accommodation disputes fairly. What should, maybe tell us what should employers, trade unions, and employees take away from this case and the TFD case?
So actually, it does seem that, ideally, and to avoid the sorts of litigation that this case has resulted in, and to resolve these matters within the workplace, there does need to be some policy and processes around that allow for early disclosure and transparency, but at the same time are done in a way that doesn't lead to unnecessarily excluding persons based on religion. So there really does need to be meaningful engagement by employers, trade unions, and employees. Organizations like Sun International are likely to operate, across multiple jurisdictions and in different cultures, and to be able to ensure that employees have general access to work-life balance, which of course includes religion and reasonable accommodation in the context of religion. So it does appear, but again, we are limited to the facts that are before us in the judgment, but it does appear that meaningful engagement on resolving this matter is somewhat lacking. It seems that the discussion starts in an incapacity hearing under the Labour Relations Act, which is inevitably leading down the route towards a dismissal. The alternative that is raised, the only alternative we see in the judgment, is to do another role, sales coordinator, but at 45% less salary, and he declined that. But it's not also clear from his perspective what he was suggesting would be good alternatives or good ways of reasonable accommodation. So it does appear that there's somewhat of a lack of meaningful engagement, which could also be perhaps not enough substance in terms of the policies and practices of the employer.
You're listening to the Labour Justice Barometer, and we'll be right back. So I think this is where I have to ask our Labour Justice Barometer question. I know where I kind of fall on the line of our barometer, but how would you rate this judgment in terms of fairness and protection of worker rights? Does this decision adequately safeguard employees from religious discrimination, or does it potentially create new risks for workers whose beliefs might conflict with the job's demands?
Yeah, sure. I do have a concern that this is creating new risks for workers on the basis of a religion. Sun International, would be a considerable employer. And my fear is that the judgment creates the risk of essentially a blanket exclusion from particular occupations or jobs where there's some expectation of weekend work. And so what is the likely impact of that? And it may not have been easy on the facts and the way the matter was pleaded and litigated, which was a Section 187 automatically unfair dismissal dispute. So the judgment itself, may not have been able to have necessarily had a different outcome. As I initially indicated, I think the time delay is a matter of concern from a labour justice perspective, but also the potential implications for persons with particular religious beliefs to be excluded from certain occupations or jobs without really engaging meaningfully in ways of reasonable accommodation, and which should apply, more broadly to employees based on their characteristics and traits and need for work-life balance. So I think these are some issues here requiring meaningful engagement in the workplace and coming up with better solutions. So, I suppose on our barometer, it would be in the orange range. What are your thoughts?
I think I agree. It's definitely an orange sort of semi-fair range on the meter. I think on one hand, it respects this principle of reasonable accommodation, but it doesn't allow employers to just jump to dismissal without any effort. But on the other hand, I think the decision still leans heavily in favor of employers, especially when considering operational needs, which could leave workers with religious obligations vulnerable. But at the same time, although the judgment complies with the law and it recognizes inherent requirements, I agree with you. It misses that deeper engagement with the constitutional right to freedom of religion and equality at work. And I think it's a bit of tricky precedent where employers might argue undue hardship too quickly without fully exploring accommodation possibilities. So I think, it might actually create new risks for religious workers, especially in certain sectors like this where you require a lot of weekend work or specific scheduling. But I think, the discussion that we've had today, there's been so much insights that you've given us, Devi, especially because it's such an important conversation. And I think this is going to be an evolving area to unpack, which I think we'll have to leave for another podcast.
Absolutely, Aisha. It's been great talking to you, and I look forward to discussing these issues in an upcoming podcast. And as always, to our listeners, we have links in the discussion, and we look forward to your thoughts. You're welcome to leave a message on Spotify or LinkedIn. Keep the conversation going. This podcast is not intended to constitute legal advice.